in the merger that took place.
Which merger? You've listed many.
Involving American Express GBT. I understand that Brian Ballard, longtime backer and head of the law firm where you work, was instrumental in lobbying the Justice Department to drop that lawsuit. It was dismissed, so it's not subject to a court review. What conversation did you have with Mr. Ballard?
Senator Blumenthal, I cannot believe that you would accuse me of impropriety when you lied about your military service.
I am
you
not
lied.
asking
You
you.
admitted you
I am
lied
not
to be
accusing you
elected
of
a U.S. senator.
impropriety. I'm
You
asking
lied.
you
How
about
dare you? I'm a
conversations
career prosecutor.
with Mr.
Don't you
Ballard,
ever challenge my integrity.
had
I have
apparently-
abided by every ethics standard. Do not question my ability to be fair and impartial as Attorney General. And anything
You'll
with
answer that
my
question to
former
another of my
firm.
colleagues.
Recent Senate questioning, something really unexpected happened. It all started when they brought up the merger involving American Express GBT. The senator asked about Brian Ballard, who has been a longtime supporter and led the law firm where Pam worked. Ballard played a key role in convincing the Justice Department to drop a lawsuit, and that dismissal meant it wouldn't be reviewed in court. Naturally, the senator probed for details on the conversations Pam had with Ballard. Then things took a turn. Pam fired back, challenging the senator's integrity by accusing him of lying about his military service, not just the usual back and forth you might expect. She was adamant, calling out the senator for his past dishonesty and firmly stating that she's a career prosecutor who holds to high ethical standards. She told him not to question her commitment to fairness and integrity as Attorney General. What's really interesting is the type of moment that can completely shift the atmosphere during congressional hearings. Typically, you see a cabinet official preparing answers, dodging tough questions with procedural tactics, and putting on a show of accountability without truly committing to any facts. But then there's that critical moment when an official makes a specific claim under oath that can be instantly proven wrong by the committee's documentary evidence right there on the spot. Pam Bondi had one of those moments on February 11th, 2026, during the House Judiciary hearing about the Epstein files. Her statement was particularly significant considering the explosive nature of the accountability issues swirling in American politics. Representative Ted was ready to counter her claims right then and there, which only added to the dramatic turn of events. So Bondi was asked by Lou if there was any evidence connecting Trump to Epstein's alleged crimes. She confidently replied that there wasn't any evidence of Trump committing a crime, which honestly raises eyebrows. Her sweeping claim invited immediate pushback from Lai and the Democrats, especially since the Department of Justice's own Epstein files, managed by her Justice Department, include sworn statements from a woman who claims under penalty of perjury that Trump assaulted her when she was a minor. There are also FBI interview summaries that contain explicit allegations of sexual assault against Trump, and by legal standards, that's considered evidence regardless of whether it has led to charges or convictions. Lou didn't hold back, accusing her of lying under oath, pointing out the survivor's statement and the FBI documents. Bondi quickly shot back, insisting, "Don't you ever accuse me of a crime." She maintained that she was telling the truth because she believes that unverified claims and civil lawsuits don't count as evidence of a crime. This explanation didn't sit well with Democrats like Representative Jamie Rassin, who argued that sworn statements, FBI memos, and civil complaints do constitute evidence, even if the DOJ hasn't indicted Trump. They accused Bondi of covering up for Epstein and siding with the perpetrators instead of the victims. Then there was Republican Thomas Massie, who, having written much of the Epstein Files Transparency Act, criticized Bondi for what he called a significant failure to uphold the law, especially when the DOJ initially released a co-conspirator list that conveniently left billionaire Leslie Wexner off until he was caught in the act. And after that hearing, things just kept rolling.
And CEO of a company that had financial ties to President Trump's business and personal ties to Trump's advisor, Steve Bannon. Second, the survivors were not similarly protected, also in violation of the law. Here is another email titled Epstein Victim List. We have blurred the names of the survivors for their protection, but your Department of Justice initially released this list of 32 survivors' names with only one.
All right, let's break this down. So we have this situation where Ted Lieu and Dan Goldman have officially called for a special counsel to look into how Pam Bondi handled certain files and what she said in her testimony. It seems that the House Oversight Committee, with a pretty close vote of 24-19, has decided to subpoena her for a closed-door deposition. They're keen to find out if she misled Congress about connections between Trump and Epstein. On top of that, the Department of Justice has started an internal review. They're checking if they wrongfully kept back records related to Epstein, which includes interview notes from a woman who alleges that both Trump and Epstein assaulted her when she was a minor back in the 1980s. It's quite something when you think about it. Here's an attorney general who stepped into a congressional hearing and boldly claimed there was no evidence that Donald Trump had committed a crime. Then, right in front of everyone, Democrats pushed into the record sworn statements from survivors and FBI memos from her own department that totally went against what she was saying. Yet she insisted her statements were accurate, diving into a definitional argument about what counts as evidence. The Democrats were quick to label her argument as nothing but word games. This entire scenario has led to what some might call a politically charged moment regarding the accountability tied to the Epstein files. It's not just about a judge declaring she committed perjury. It's about how the facts she tried to present were pretty much torn apart in real time by the very evidence her department produced, thanks to the transparency law she's accused of selectively following. And now all of this is fueling the special counsel request and that subpoena for her testimony behind closed doors. It's all about whether those specific notes that contradicted her claims were improperly kept out of the public record, which was legally required to be accessible. Before diving deeper, I can't help but notice that the framing of this story is important. The headlines say Bondi was caught lying and then shut down, but understanding the specifics requires a bit more precision to really capture what the documented record shows. It's honestly hard to believe the drama surrounding Pam Bondi lately. While no judge has officially determined that she committed perjury during the hearing on February 11th, what stands out is the operational impact of what went down. Under oath, she made a sweeping claim that was quickly shot down by documentary evidence brought forth by Democrats in real time. She tried to defend her assertion using a definition of what constitutes evidence, but the Democrats, the special counsel, and the subpoena showed that her claims were misleading. Talk about a tough spot. The combination of being dismantled in real time and the subsequent responses from the special counsel and others highlights just how significant her no evidence claim is in this whole Epstein accountability saga. In reality, it wasn't a judge who put a stop to her defense. It was the facts themselves, especially those documents right from her department, which contradicted her sworn claim. And when you consider the wave of investigations into her conduct following that hearing, it's clear how badly her no evidence assertion fell flat. Louis summed it up well when he referred to her actions as lies, and the record of accountability only reinforces that. Now, let's break down the Bondi no evidence hearing because it has 4 key layers we need to explore. The first is her specific sworn statement, which invited immediate confrontation with the actual documents that disproved her claim. Next, there's her defensive response about never being accused of a crime and her argument about unverified allegations not counting as evidence. Those word games only reinforce the perception of a cover-up narrative. Then we have the findings related to Massey and Wexner, which serve as another accountability layer within the hearing record. Each of these elements plays a crucial role in understanding the full picture of what happened. The whole situation really highlights the pressure that the special counsel's oversight and the internal review by the Department of Justice create around accountability. It's interesting to dive into the no evidence claim first, because that sweeping statement plays a huge role in why it became so easily countered by the immediate use of documents that reveal more. When Donald Trump insisted there was no evidence he committed a crime, that claim turned out to be one of the most legally risky ones in all of the testimony surrounding Epstein. It's a bold denial that opens the door wide for documentary evidence, particularly because the Department of Justice's own Epstein files provide strong backing for what the documents say. Think about it. Claiming there's no evidence is a pretty strong stance, but one that can fall apart with even a single piece of actual evidence. This sweeping assertion unintentionally makes it easier for opponents to challenge their position using any relevant document that fits the legal idea of evidence. A more carefully chosen response, something along the lines of insufficient admissible evidence to support charges, would have better shielded them from confrontation. The outright denial of any evidence shifted the entire hearing from what could have been a smooth political defense into a situation ripe for dismantling, leading to a wave of accountability afterward. It's worth noting that the Attorney General of the United States, being the top law enforcement officer, should truly understand the exact legal definition of evidence, especially when she's using the claim of no evidence as a response to Congress about documents her own department was handling, claiming there's no evidence while those documents include sworn accounts from survivors alleging crimes and detailed FBI summaries of assault allegations creates a serious contradiction that raises all sorts of questions about the accuracy of that sworn statement. It's pretty interesting how the whole discussion centered around an argument of what counts as evidence. Right off the bat, the Democrats completely dismissed it as just playing with words. That characterization really sets the tone for why the claim of no evidence is seen as misleading, especially in the context of the special counsel's request and the subpoena. Instead of being viewed as the sound professional judgment of an attorney general evaluating evidence, it comes off as something else entirely. When Lou jumped in with a sworn statement from a survivor in an FBI summary, it really showed the heart of the matter. These documents are recognized in the legal world as evidence. Dismissing the no evidence claim is almost laughable when you consider that a sworn statement from someone who claims to have been raped under penalty of perjury is clearly evidence under the law. Now, it's not a guaranteed win for convicting someone, and it might not always meet every standard for a trial, but fundamentally denying that as evidence really shifts the narrative. When Bondi said there was no evidence, the argument would have been a bit stronger if she had instead claimed there wasn't enough to charge or convict, which would have been more accurate. That statement would have been less susceptible to Lowe's immediate pushback with actual evidence right in front of them. And then there are the FBI interview summaries, which are another layer of evidence that adds to the challenge of the no evidence claim. Those summaries are formal documents that count legally, regardless of whether the claims made in them have been proven or even taken to trial. So when Bondi claims there's no evidence while overlooking documentation from her own department, it makes the argument quite shaky. It's like saying, this is evidence right here, and Lou had that on display in real time. The DOJ has labeled those allegations as unverified and sensational, giving their professional take on how much weight they carry in terms of evidentiary value. It's fascinating how the terms unverified and no evidence often get mixed up, isn't it? This blurring of lines is precisely the type of word play the Democrats use to twist definitions in a way that supports their narrative of a cover-up instead of making a legal distinction. One of the most damaging moments for Pam Bondi during the hearing was her defensive reaction of, "Don't you ever accuse me of a crime." That response just screams defensiveness. It doesn't convey the confidence you'd expect from someone who truly believes in the accuracy of their statements. An attorney general who stands by her claim that there's no evidence should calmly lay out the legal framework, clarify the difference between unverified claims and real actionable evidence, and invite further investigation if there are contradicting documents. Instead, when someone snaps back with a defensive comment, it suggests they are feeling the pressure, especially when there's a disconnect between what they've sworn to and the evidence at hand. That quick comeback from Bondi is going to be replayed in every discussion about her testimony on February 11th, and it isn't because it proves she committed perjury. Rather, it highlights her defensiveness and lends weight to the allegations of lying under oath. People will undoubtedly take note of how that moment portrayed the credibility of her sworn statements, which is crucial. Her hearing didn't just showcase a reasonable legal defense. It instead became a prime example of how political narratives are shaped and amplified through emotional responses. The distinction between unverified allegations and real evidence is key to understanding the situation, and unfortunately for her, it fell flat during that hearing. The whole discussion around allegations and evidence can be pretty baffling, especially when it comes to what counts as evidence in a criminal investigation. It's honestly hard to believe that some people think that unverified claims shouldn't be seen as evidence at all. In reality, that's not how it works. For something to be considered evidence, it doesn't need to have every detail confirmed. It just has to be the type of document that investigators would gather to see if it's relevant to their inquiries. Things like FBI interview summaries and sworn statements from survivors are prime examples of the kinds of documentation that examinations look at, regardless of whether those claims have been confirmed or not. When someone argues that these unverified summaries don't hold any weight as evidence, they're really missing the point of what's legally acceptable during the initial stages of an investigation before any charges are brought. It's interesting to see how this argument is used to push the idea that there's no evidence at all, which honestly sounds a lot like trying to spin things to suit a narrative. Those toying with these definitions seem to turn the whole situation into a cover-up story instead of sticking to a sound legal argument. Even more eyebrow-raising are the findings about the Massey red-handed and Wexner omissions, revealing a bipartisan angle to Bondi's accountability record. Here's a Republican who's called out the Department of Justice for failing to stick to the law signed by the president, and it's hard to ignore how he pointed out that they conveniently omitted Wexner's name from the list of co-conspirators until he had to push for that correction himself. What's fascinating is that these same accountability findings are incredibly effective in countering the narrative that this whole hearing is just a political show for Democrats. The way they characterized everything, especially around Massey's statement of being red-handed, really highlights how intentional those omissions were. It's clear there's a lot more going on here than just bureaucratic errors. It's honestly hard to wrap my head around how the term red-handed fits so perfectly when discussing catching someone in the act of hiding information. It highlights a deliberate move, not just the result of a random mistake. Later on, when we think about the Wexner name, it's a real example of this pattern of selectively holding back information, which is what Massey's red-handed description really nails. This all ties back to the same hearing where Bondi claimed there was no evidence to support certain allegations, forming a backdrop that underscores a systematic approach to managing information. Bondi's testimony was trying to deflect from serious questions being raised. It's interesting to see how Liu and Goldman are now pushing for a special counsel investigation, showing a demand for accountability that escalated right after that hearing. This isn't just minor. It's a formal request for a thorough, independent look into whether Bondi misled Congress in her testimony. You can't ignore the context. Right after a hearing where the Attorney General's statements were directly contradicted by documents in her own department's files, these Congress members felt the typical oversight methods weren't enough. They needed a fresh set of eyes to see if her sworn testimony actually matched the facts laid out in those files. The controversy raises an important question about whether the Attorney General made a statement to Congress that she either knew was false or should have known was opposed by the evidence available at the time. That's the heart of the matter, and it's what the subpoena for a private deposition aims to clarify using a perjury mechanism that turns every answer Bondi provides into a sworn statement. The internal review by the Department of Justice regarding the Epstein records is a pretty big deal. It's like they finally acknowledged that there's genuine concern about how they handled the release of information. Initially, they were standing firm, insisting their management was in line with transparency laws during the hearings. Now, though, they're taking a step back to question whether that management was actually appropriate. What's caught my attention is that this review is zeroing in on interview notes from a woman who claimed she was assaulted by Trump and Epstein when she was a minor. Those notes are crucial because they directly challenge the assertions made during the hearings that there was no evidence. When a survivor details criminal behavior, those accounts become essential in assessing whether the department's previous claims were accurate. This internal review could be seen as the department admitting they are under serious scrutiny and that there are valid concerns about their past actions. It seems they might be feeling the pressure to examine their conduct more closely, especially since the focus of the review aligns so closely with the no evidence claims raised in the hearings. So, as they evaluate their past decisions, it might just confirm the Democrats' earlier criticisms about improper withholding of information. It's honestly hard to believe we're witnessing such a shift in their approach. There's been some serious talk surrounding the Bondi and Epstein situation, especially with how well the congressional hearing captured everything. You'll find sworn statements from survivors and FBI summaries straight from the Department of Justice's files shedding light on the truth. So when we look at the mess that unfolded, the immediate fallout from these claims really dismantled the unverified allegations and all those word games. The hearing painted a pretty clear picture, showing accountability across the board, including a notable moment involving Wexner that highlighted bipartisan responsibility, which is pretty something when you think about it. Then there's the special counsel's push for an independent review, which came after all this back and forth. That's a big step in terms of the Justice Department stepping up and owning what's going on. Looking at the details, it's interesting how the pushback against the claims of no evidence became such a pivotal part of the entire testimony. It's honestly hard to believe Bondi's claim that Donald Trump didn't commit any crimes is the single most crucial statement in the whole Epstein files testimony, especially since it directly invited scrutiny from the documentary evidence. The claims from the Board of Justice seem to completely back up the points being challenged. Then we come to the hearing itself. That moment when the response was more defensive than authoritative was telling. It showed vulnerability instead of confidence. The so-called definitional defense seemed to turn into an admission confirming the cover-up narrative. In summary, the Bondi-Epstein saga has sparked a wave of accountability, and as we dig into it, the congressional record is being built on real-time sworn testimonies. With all this in hand, we're looking at the foundation for upcoming questioning that will put Bondi's statements against the actual evidence the DOJ had on file. This is definitely a situation to watch. It's really something to see how the hearing shifted from a carefully managed political defense into a moment of real accountability. The Attorney General of the United States was on the stand testifying about files that her own department was handling. She gave a sweeping denial of the document's contents using language that was incredibly easy to contradict with the actual files they had produced. The gap between her no evidence claim and the documented evidence is precisely what the special counsel's requests and oversight subpoenas are built on. This is a direct response to the pivotal moment of the hearing. Then there was that intense moment on February 11th when a witness snapped back with, "Don't you ever accuse me of a crime." That burst of defensiveness stood out as one of the most politically damaging aspects of the hearing. It highlighted how witnesses often react when their sworn statements are challenged by evidence. What's significant is not just that this moment might hint at perjury in legal terms, but rather that it strongly supports the claim of lying under oath in the eyes of the public and accountability audiences watching the proceedings. When a witness truly believes in the accuracy of their statement, they calmly explain the legal principles backing their answer. On the other hand, when someone reacts with anger and defensiveness, like snapping back at accusations, it signals to everyone watching that they are aware of the vulnerabilities exposed by the documents confronting them. This emotional response is key and definitely shapes how the audience interprets the validity of their sworn statement. Finally, the findings from Massey and Wexner are some of the most politically significant parts of the hearing, especially since they come from a key institutional figure. These insights are crucial in understanding the dynamics at play within that specific party's accountability surrounding the hearing. The February 11th hearing really set the stage for some significant fallout. It's created what I'd call the most important sworn statement in the entire record of congressional testimony related to the Epstein files. And it's not just the potential for a perjury finding that makes it stand out. It's all about how it practically exposed the gap between what was claimed under oath and the documentary evidence we have. To understand this better, a Republican who happens to be the author of the Epstein Files Transparency Act pointed out to the Republican Attorney General that her office had seriously dropped the ball on following the statute. It's pretty striking when the Republican president had to step in and personally push for a correction because the department initially left a particular name off a required disclosure list. This incident doesn't just reflect poorly on the department, it also provides a solid narrative of accountability coming directly from the law's own author, rather than being just partisan attacks from political opponents. This kind of institutional credibility is why the contributions from the Massey hearing are so critical. They add authority to the accountability narrative, especially given that it comes from someone within the same political party. Now, there's a wave building after the hearing emphasizing point 4 about the situation. The special counsel's demands and the oversight subpoena work hand in hand to turn that gap between the claim and the evidence into real calls for accountability, specifically for an independent investigation and a closed-door deposition where any potential perjury issues could be addressed. The internal review at the Department of Justice is particularly telling as it backs up the claim of improper withholding by showing that the office believes the pressure for accountability post-hearing is serious enough to require a thorough examination of their actions, especially regarding the claims of having no evidence.